Welcome to this training session on a framework for pretrial justice, essential elements of an effective pretrial justice system and pretrial service agencies. This framework comes from the National Institute of Corrections and is supported by national standards from the National Association of Pretrial Service Agencies.
The framework encompasses 4 dimensions. The first and most important is the law. What is the legal basis for release and detention prescribed in state and federal bail laws? Case law and other legal opinion. The New Mexico Constitution and case law in New Mexico are reaffirming the basic principles of bail. Second are the standards for pretrial release as adopted by groups such as the National Association of Pretrial Service Agencies, the American Bar Association, and National District Attorneys Association, as well as state-specific standards. The third is research and evidence-based practices associated with pretrial release, particularly validated risk assessment, risk mitigation strategies, and supervision best practices. And the fourth is organizational theory, describing the elements and practices of high-performing organizations, such as the emphasis on staff and customer satisfaction, work and functions associated with the clear mission and use of outcome and performance measurement and feedback.
American courts process millions of criminal cases a year. Each requires a judicial officer to determine if a defendant should be released and under what conditions. This is one of the most important decisions in criminal case processing. However, most judicial officers do not have information nor appropriate release options available to make the best bail decision. Moreover, most systems lack the structure needed to monitor released defendants, screen detained defendants regularly to release eligibility, and safeguard individual rights and community safety.
The goals of pretrial are referred to as the 3 M's. They are maximize court appearance, maximize public safety, and maximize release.
In New Mexico, our legal framework follows these legal foundations listed. All defendants in New Mexico are presumed to be releasable. Money should not be used except in limited circumstances dealing with court appearance and not more than a defendant can afford. And there should be a legal mechanism to detain, with no conditions including the use of money when individuals pose a public safety risk. All 3 of these components are interrelated and must exist within a legal framework to achieve maximized release, maximized court appearance, and maximized public safety.
Our New Mexico law follows and is supported by 2 important federal cases. The first is Stack v. Boyle that emphasizes that money can only be used for purposes of court appearance and cannot be used to detain a defendant. U.S. v. Salerno is the second federal case, and it supports the New Mexico Constitution. Defendants should only be held in custody if it is established that they pose a threat to the safety of the community and no conditions of release exist that mitigate that threat. In the U.S. v. Salerno opinion, Supreme Court Justice William Rehnquist wrote, "In our society, liberty is the norm, and detention prior to trial or without trial is the carefully limited exception. In New Mexico, all defendants are presumed releasable unless the constitutional requirements for preventive detention are met."
So let's get into the elements of a high-functioning pretrial justice system. First, pretrial release and detention decisions based on risk and designed to maximize release, court appearance, and public safety. Next, legal framework that includes a presumption of least restrictive non-financial release, which we have in New Mexico, restrictions or prohibitions against the use of secured financial conditions, which we have in New Mexico as well, except in limited circumstances, and preventive detention that is limited and clearly defined. Again, New Mexico has preventive detention for felony cases. For example, courts are far less likely to utilize formal preventive detention when secured financial conditions are allowed. Presumptive non-financial release, along with real and practical supervision options, keeps systems from applying preventive detention to an unnecessarily large defendant population or resulting in high bond amounts for high-risk defendants. Release options following or in lieu of arrest. This would be an early delegated release program or other types of diversionary programs meant to target certain types of defendants and move them outside the criminal justice system and address needs. No locally imposed exclusions not permitted by statute. This would mean that no jurisdiction or city or county could have their own exclusions based off of charges and treat them differently than what is allowed by statute. And experienced prosecutors screen cases prior to the initial appearance. This is where prosecutors basically are screening those cases before they come into the system to make sure there's no issues with the cases, that they're charged correctly, and that the cases are appropriate for prosecution. The last three elements of a high-functioning pretrial justice system are active defense at first appearance, a collaborative group of stakeholders that employs evidence-based decision-making, and a dedicated pretrial service agency.
Every high-functioning pretrial services agency should have these important elements: an operationalized mission, universal screening, a validated pretrial risk assessment, sequential bail review, risk-based supervision, and performance measurement.
So what do pretrial service agencies do? 1, they help courts make informed bail decisions by conducting pretrial outcome risk assessments and providing recommendations. 2, they promote maximized release, appearance, public safety, and successful outcomes. And 3, they ensure that release options are realistic and measurable.
What are some of the functions of a pretrial services agency? Some of these functions are to assess, adjust, and to recommend. So to assess by gathering data and applying that data to the validated risk assessment tool. Second is to adjust and consider mitigating and aggravating circumstances related to the individual defendant. And the third is to recommend supervision level and conditions consistent to the risk. It is important that pretrial services agencies are independent entities that operate specific to the pretrial population. It's important that they have a clearly defined function and that they have dedicated staff with knowledge and experience in working with pretrial release and pretrial supervision. How do pretrial services agencies assess? While they complete a background investigation and criminal history check, they utilize this information to conduct a validated risk assessment, and they make recommendations to the court that help judicial officers with important release decisions.
Pretrial service agencies in local jurisdictions promote pretrial success. They promote court appearance and public safety. This is accomplished by providing legal and evidence-based supervision, monitoring, and supporting the defendants in their compliance with conditions of release. When appropriate, local pretrial programs should assist defendants with accessing behavioral health services. It is important to keep in mind that because a defendant is on supervision does not mean defendants should be required to engage in services. Services should only be required when a defendant's pretrial risk, their likelihood of making all court appearances, and not having new arrests increases because of their needs. Pretrial programs should not work under the idea of, now that I have you, what can I make you do? In addition, behavioral health and engagement in those services should not be tied to one's liberty. With that said, programs should offer defendants community options and assist in making those connections whenever possible.
How do pretrial services agencies know that they are successful and that they are operating at their highest efficiencies? That's where measurement comes in. Pretrial services agencies need to be able to provide metrics, satisfaction, and feedback to improve policy, procedures, and operations within the pretrial justice system. What is an operationalized mission statement and why is it important? Well, your mission statement tells the world who you are and why you're important. It guides agency structure, focuses on goals and principles, and it defines ultimately who your agency is. Everyone within your organization should know and understand your operationalized mission statement.
An example of a good mission statement is the mission statement of the Administrative Office of the Court's Pretrial Justice Program. The mission is to foster and enhance pretrial justice throughout New Mexico. A mission statement should be short, ideally less than 10 words, and be clear to the point of the program. And the vision of the AOC Pretrial Justice Program is for New Mexico to continue to be a national leader in pretrial justice. Another critical component of a pretrial services program is universal screening. Pretrial service agencies should screen all defendants eligible by statute for bail to make informed, individualized recommendations to the court.
The New Mexico Administrative Office of the Court's Background Investigation and Public Safety Assessment Unit receive booking information from local detention centers throughout New Mexico, and they initiate cases in the New Mexico Court Case Management System, Odyssey. New Mexico was the first in the country to implement a centralized, statewide background investigation unit. The unit conducts background investigation and provides background investigation reports, BIRs, and public safety assessments, PSAs, for use by judicial officers at an initial liberty hearing.
The use of a validated pretrial risk assessment tool is used to measure a defendant's likelihood of making all scheduled court appearances and remaining arrest-free during the pretrial stage of their case. The tool is objective information provided to the judge to assist in release decision-making. It is important to keep in mind that a risk assessment tool is just that, a tool. Judges have many things they must consider when making release decisions.
One of the core functions of a pretrial services agency is a pretrial risk assessment. A pretrial risk assessment is meant to inform a bail decision, so an initial appearance judge who is setting bail conditions for individuals. One of the things that we do in pretrial is to give them information to make a fair, equitable decision. PSA court tool is a tool we use in a risk assessment to help us inform the court about the probability or the likelihood someone could get rearrested or incur new criminal activity or fail to appear in court. It looks at several criminal history factors that are important in helping make that recommendation and helping the judge make a decision. And we found it a very effective tool in determining who is more likely to succeed during the pretrial period. It's one of the things that we utilize to help us give the best information to the court and the parties. And it's one thing that I feel I have plenty of confidence as a pretrial practitioner, and any analysis we do around it supports that it's doing its job and being effective.
Sequential bail review is the process in which a defendant has already gone before the court. The judge has ordered their release with conditions. However, the release has not occurred because a condition, perhaps a financial condition, has prevented their release. The process of sequential bail review allows conditions to be reviewed and changed to allow the release to occur.
Once a release decision has been made and conditions ordered for a defendant to include a money bond, that money bond may be preventing that person from being released from custody. That person and their case are then brought back before the judge who set the conditions of release to review and possibly modify them and allow them to be released from custody. The process of the case being brought back before that judge is known as sequential bail review. In New Mexico, cases are set for review within 3 to 5 days after conditions are ordered in the magistrate court. In the district court, however, a motion for request for review has to be filed by the defense attorney.
The rules for New Mexico pretrial release can be found in 5-401 for the district courts and 6-401 for magistrate courts. One piece of this rule is that if a defendant remains in custody 24 hours after the issuance of a monetary bond, that defendant shall, on motion of the defendant or court, be entitled to a hearing to review conditions of release.
You may remember in an earlier learning session the motto referenced, "The law tells us what we can do and evidence-based tells us what works." Risk-based supervision comes from this concept. Risk-based supervision uses least restrictive conditions needed to promote court appearance and public safety.
I believe pretrial supervision is really focused on monitoring conditions of release. So we have a bail hearing, a judge sets release conditions for an individual, a defendant, and pretrial services supervision or pretrial supervision is making sure that the defendant is adhering to those conditions. That's the primary core function of supervision, in my viewpoint, is that you monitor those conditions and really make sure the court is aware of what that defendant individual is doing. So that's the core function. I think also we have an obligation to try to make sure that that individual is also receiving other services if they need to receive them. So if someone comes in and they're in for a certain charge, they have certain conditions of release attached to that charge. I think we have an obligation or a need to have a conversation with that person and talk to them about what what things we can help them address that'll help mitigate any obstacles they have for that, adhering to those conditions of release, getting to court. So really, I think it's a comprehensive set of goals, reminding ourselves that the key function of supervision is to monitor conditions of release.
What have we learned in pretrial supervision? Decades of pretrial justice research have shown most defendants will make scheduled court hearings and remain arrest-free. The goal of legal and evidence-based supervision is to support and promote success. Over-supervision with punitive supervision have been shown to produce poor outcomes. Remembering, defendants are innocent until proven guilty. Taking a less is more approach and applying evidence-based strategies produce good outcomes.
We have created a culture in Dallas County where the judges understand that electronic monitoring cases should be those individuals that you're most concerned about, so that you don't have low-level individuals using up that resource.
Okay. And one final question.
Yes, sir.
If you could change the way that you do supervision, how would you change it?
Interesting question. I think we would be less restrictive. This is pretrial, and pretrial is supposed to be the least restrictive measure to get the individual back to court and ensure compliance with the conditions.
One of the main goals and functions of a pretrial services agency is to support court appearance and non-rearrest while the defendant is released on pretrial. Some effective supervision includes court date notification. This is either through an automated court hearing reminder system or through manually contacting defendants and notifying them of upcoming court hearings. It's important to have early and meaningful responses to conduct, both negative and positive. Pretrial staff should also be providing notification to the court in response to defendant conduct. A supportive services model is something that we will cover in another module. Pretrial services staff want to assist and make referrals for any potential behavioral health needs that are identified. Treatment cannot and should not be forced upon defendants unless ordered by the court. Participation in treatment should also not be tied to a defendant's liberty, but we do want to support behavioral health.
So you've worked in a jurisdiction where services and support were available to defendants, and you've worked in jurisdictions where they weren't. What are the differences? What are the advantages of having those kinds of support and services available to individuals at the pretrial stage?
Well, evidence tells us that people who fail to appear in court, typically the reasons are based in things outside of whether they're committed to coming to court. So if someone has social concerns, if someone is facing poverty, if someone has unstable housing or doesn't know where their next meal is coming from, it's hard to focus on coming to court. So when we can provide them services through a social worker, for example, we can help them be successful instead of putting up obstacles that are only going to help them fail. If we could order people who are addicts to not behave like addicts, we wouldn't be losing 100,000 people a year to addiction. We look at a risk assessment and we say, here are the things that put you at a higher risk. And therefore, those are the things I'm going to help you fix, as opposed to those are the things that I'm going to keep a close eye on. And I think that's where we're seeing measurable success, when pretrial officers look at their role as helping someone succeed instead of catching them when they fail.
Okay. And knowing how dynamic cases can be in the system, you could have a pending case today, it gets dismissed tomorrow. Are we looking at treatment episodes that are ordered by the court, or are we looking at something that's outside of conditions of supervision?
As far as ordering treatment?
Yeah.
I think ordering treatment is just an idea someone came up with that is not based in evidence whatsoever. If someone really wants treatment, we absolutely should be able to offer that to them. But I think when you tell someone you're going to get clean because I said so, we all know that the evidence says that doesn't work. Again, if we could order people to get clean, we wouldn't have a multi-billion-dollar rehab industry.
So you see this as more of a supplement to the case itself, and certainly not part of the case or court order, if that's what I'm hearing correctly.
Absolutely. I mean, when someone's arrested, they are presumed innocent, and we shouldn't be thinking of how are we going to penalize them for not behaving appropriately at this stage. Facing a court case takes a lot of focus. It takes the ability to listen, to cooperate with your attorney, to understand what's going on. Your liberty is at stake. A lot of things are at stake. And if you are distracted because you haven't had a good meal in a week and you don't know where you're going to sleep tonight, you really can't put your focus on this very important matter. I mean, our court systems were originally designed for the benefit of hearing out and giving a process to someone who's accused. And I think it's kind of morphed away from that too much.
So we know that defendant populations have needs, substance abuse, mental health, support services. We have a population where those needs are quite great. In your opinion, what is the best delivery mechanism? What's the best model for getting those kinds of services to a pretrial population?
Thank you for that question. I think the best model is what we're calling a community collaborative model that has individuals that are involved in the justice system, but also individuals that are not involved. So community-based organizations that can all come together, if you will, and leverage the existing resources that are provided in the community. So in essence, it would be identifying the need within the pretrial service agency, having a primary point of contact that would be do that warm handoff to that CBO, but making sure that the community takes it on, because what it does from that standpoint, it allows for an opportunity for that service provision to continue on beyond and outside of the pretrial stage of a case.
Okay. Now, in your opinion as well, into that model, if I am that provider of services, where are the resources going to come from? Because we are saying, again, this is a population with a lot of needs. We don't want to overburden the systems that we now have. Are we seeing more state, federal funding to these communities? Do the courts have to open up and start funding some of this stuff?
Yeah, I think the best model would be to leverage those existing nonprofits that are already providing treatment for mental illness and for substance use, or for, housing authorities within the community. Oftentimes within local governments, there's silos, and so some of this, justice, legal, criminal justice, legal system folks are not always aware of what's available within the community. So one of the things that we offer, and I know it's outside this space, and you can cut this piece out if you need to, but we have this resource called an inventory of pretrial services, basically that itemizes what the service is, who provides that service, and what that connection looks like. Okay. Because oftentimes there's silos. Even within the same system, what we're finding is that judges may not know what pretrial services can refer to. Sometimes even within an agency, the staff may not know. And so just being able to bring all that to one place and have somebody that is the primary point of contact, well, we saw that as being a really successful model in terms of referrals, so that they're not just given a piece of paper and say, report to this place, but there is a true warm handoff from that one, identifying that need, connecting them to that resource so they can move on in that space in terms of being able to get that support. So leveraging existing community-based organizations that are already doing that work, as compared to making that an additional array or, a burden, if you will, to some degree within a pretrial service agency.
Back to performance measures and the importance of being able to say something about your program and its effectiveness. So how do we measure for results? In New Mexico, we utilize a guide from the National Institute of Corrections, Measuring What Matters, the second edition, to assist us in determining if we are an effective pretrial services program. Some of the most important metrics that we utilize are release rates. Of the total population that have cases filed within the courts, how many of those defendants are released pretrial? Appearance rates. Of all defendants that are released from custody, how many of those appear for all court hearings while their case is pending? Safety rates. Of defendants that are released and out of custody pending trial, how many of those defendants do not pick up new charges while their case is pending? And success rates, which is a combination of appearance and safety. Which defendants were successful while they were on pretrial release and did not fail to appear or pick up new charges while their case was pending? How do we utilize these measures to meet our goals? What are our goals? Our goals are to achieve better results in public safety and court appearance. We want to create a results-oriented culture. We want to allow pretrial agencies to show solid performance and allow better decisions on agency resources, quality, and effectiveness. In New Mexico, we are gathering and now able to provide important feedback and data to our New Mexico pretrial sites and criminal justice partners. The charts seen here utilize pretrial data for our supervised population as well as all defendants pending trial. Here we're looking at data from 4 of our pretrial AOC sites, including the 3rd Judicial District, the 6th Judicial District, San Juan County, and Sandoval County. These charts show that the majority of pretrial defendants are successful while on pretrial release.